we're going to do like... Yeah. All right, we're getting ready for the next panel. All right, so we are going to get started with the second panel, which is all about career paths in the private and the nonprofit sectors. And my name is Rebecca Williford, and I'm really excited to be here today. This is Brette, Steele on my left, and I were actually counting up. This is our 6th conference, and Brette and I were here for the very first one. We were law students who came together during a time where there was no community whatsoever, and law students were spread out all over the country. There was no sense of network, no sense of support. We initially came together over a lot of accommodations issues that folks were having. People were still frustrated about issues that are still relevant today with LSAT accommodations and getting access to textbooks and all media formats in a timely manner. And we're all still working on it, but it's good that we're all working on it together now, and the org is growing, and it's really exciting to come back year after year and see fresh faces and see that the torch is being passed on to good folks, because it's really important. And I know law school can be a difficult place to sort of be out and proud about our disabilities, but you really are doing good work by carrying the torch, and unfortunately having to be the poster child, even when you don't want to be sometimes, for others with disabilities and for access issues. So I've been practicing law now for about 2.5 years, and I grew up in North Carolina and went to law school there in Chapel Hill, and then jumped ship and moved to Berkeley, where I practice disability rights law, a disability rights advocate, and we do class actions representing people with all types of disabilities. Carla, who just spoke, was one of my favorite colleagues who recently left us. So I'm very excited to have opportunities to come back to DC and see great folks like her. I am not the main event, so I'm going to stop talking, and we're going to do quick intros, and then Brette, Steele, Stephanie Ortoleva, and Peter Thomas are each going to talk for about 15 minutes about career paths, accommodations, what their experience was, and to the extent, I know we have a government employment panel coming up later, so to the extent folks can sort of contrast, what's distinct about the non-government sector, that's fantastic. I'm sure we'll also touch on disclosure, even though I know that the first panel did that as well. And we're going to try to leave the last 15 minutes for questions. So get your questions ready. All right, so we'll do quick intros. Take it away, Brette.
All right, so I am Brette Steele, and as Rebecca mentioned, I was at the very first founding conference over 5 years ago now, and it is so nice to see a room full of people who are not fighting with each other. Can't even tell you. So my career path, I graduated from UCLA in 2007, clerked on the Ninth Circuit, went to Mayor Brown's Supreme Court practice here in Washington, D.C., was there for 2.5 years, and actually moved to the government a year ago. I'm in the Office of Legal Policy at the Department of Justice, but I'm here to talk about private practice today. Stephanie.
I guess good morning. I'm Stephanie Ortoleva. I'm an international human rights lawyer. I went to law school at Hofstra University on Long Island some years ago. One of the illustrative points of how it was some years ago is that when I was applying to law school, the LSAT was not, in fact, accessible, and no accommodations were offered, such that it was impossible for me to take the exam. And when I wrote to law schools, including some of the more prestigious ones in this country, which I would have qualified to enter, they said, how can you possibly expect to be a lawyer if you can't read? So at least I would say things have changed. I've practiced in the not-for-profit, the government, and in what I guess I would call the quasi-private sector as well. So it's wonderful to be here, and there was not even a whisper of an organization such as this when I went to law school. So it's lovely that it's here now.
And I'm Peter Thomas. I went to Boston College and Georgetown Law School here in town and began doing some legislative work that I'll tell you about a little bit more in depth during my 15 minutes, and wound up getting the Washington bug, as they say, and really enjoying practicing here in town and do a lot of healthcare, rehabilitation, and disability law and lobbying and regulatory work, and work a lot with coalitions and other organizations representing people with disabilities and chronic conditions. And I'm really happy to be here.
All right, Brette.
All right, so I wanted to share two contrasting experiences in private practice because I think it really shows just how differently disability can be approached and discussed. So when I was a law student, like many of you are today, I was a 2L, did not have any concept that I would soon have a disability whatsoever. And I was interviewing at OCI. And so I interviewed with a top 3 law firm and was offered a job and was really excited to start there that summer. And about 4 months later, I developed double vision and had to learn how to use text-to-speech software and learn how to work with my new disability. And I told the firm that December, as soon as it happened, I said, you know, FYI, this is happening. I am going for treatment 4 days a week at this point. I don't know where it'll be this summer, but I just wanted to let you know. And they said, that's okay, we'll work with it. And I kept them up to date, and I got there that summer, and I had told them I needed a scanner, and they got me a flatbed scanner that could scan 1 page in 2 minutes. And I brought a copy of Kurzweil. I brought my own copy of Kurzweil, and they absolutely had no idea how to make this work, and I was new to this, so I was trying to teach them at the same time as I was trying to learn it. And, you know, it worked really well for about the first 8 weeks. And then one of the associates decided she needed to test this out. And so she gave me 12,000 utility bills to review and chart in the next 24 hours. And if you've ever read a utility bill, the only thing you care about is the price. But there's a whole page of text that if you're listening, you have to listen to in order to get that one stupid number. And so all of the partners happened to be out of town this day. Don't know whether or not that was strategic on the associate's part. But all of the partners happened to be out of town, so I went to the associate. I explained what the problem was. I first tried using an eye patch to block out one of the double images. I was still losing the feeling in my hands and losing my vision. And so I asked for a reader, and she said, you know, we don't have anyone who can serve as a reader. Another associate offered to do the assignment for me. I asked if we could transfer it to him. No, we can't do that. I asked, he said, you know, I have nothing to do. I can just read it to you. So they're still using, you know, your processing power. No, they wouldn't do that. They refused all accommodations. I lost my vision completely, ended up in the hospital for a week, and came back to the firm and said, look, I loved working here until last week, but I need to know that there will be some accommodations if I'm going to come back. Because they said, we absolutely love you and we want you to come back. And it's just like, you're not showing that. So I talked with them, okay, in order for me to be willing to come back, I need to know that if there are assignments like this, I will have a reader. And they said, well, we're not comfortable with the concept of reader because we're paying for your brain and not someone else's. It's like, you don't understand what a reader does. You're still getting my brain. And so it was really a difficult conversation and a difficult experience. And ultimately, it came out at one point, they said, look, when we interviewed you, we didn't know this was going to be an issue. And it's just like, yes, when you interviewed me, I didn't know this was going to be an issue. But we're working with it here today. So probably no surprise that when I got back to law school and lined up my clerkship for the following year, I decided maybe I should go to another firm where I might actually get accommodations. And so my experience at Mayor Brown, where I worked for 2.5 years, was night and day different. They asked me what accommodations I needed. They got me a scanner that scanned, I think, 50 pages a minute with a document feeder. They also had a whole staff of 5 people that I could use to do scanning for me, and had after-hours staff to do scanning for me. They got me both JAWS and Kurzweil, called me a week before I started and said, we've tested the software, it's up and running, it's working, but we're not entirely sure we can teach you how to use it just yet. And I said, no, it's okay. I can teach you how to use it. I just need the software to be up and running. But they tried so hard. And they knew exactly what they were getting because I had talked to them about it beforehand. And it really is amazing to see the difference when a firm wants to accommodate you versus begrudgingly does so and feels like they've been baited and switched even though they haven't been. And so what I would say, and I know disclosure was mentioned in the last panel, but what I would say is disclosure is your friend because you don't want to go someplace that doesn't want to work with you. And I know it's a hard economy and I know you want to get jobs, but you really want to go someplace that will make your experience positive. And now being in the government, I can tell you there is value to being in the private sector where they have the money and less bureaucracy to make your accommodations happen quickly. I mean, I love the government, but there really is value to the private sector on that front. So my firm was fabulous. We had one other person who had a different type of visual disability, and they gave her the exact accommodations she requested that were different from mine. I mean, they recognized that you needed to talk to each person differently, and you do need to educate your firm and educate the people you're working with, but it can really work well if you're upfront at the outset and you find a firm that wants to work with you. So with that, I'll pass it on.
Well, hello again. Just let me know if you can hear me properly. Anyway, my career has taken a number of paths, and I thought I would just go a little bit into that and give a couple of pointers from my own personal experience. When I started in law school, as I mentioned, I did go to a very welcoming and accommodating law school, but I was actually the only person with a disability that was attending the law school, at least that I knew, in terms of people disclosing. I had much more vision at that time. Now I basically have none. And it was an interesting experience, and where I found a community, because I didn't have a community of law students with disabilities, was a community of women in law school. Because although my law school was somewhat progressive and there were a good number of women who were students, there was a small number of women who were professors. So I think I learned about a solidarity experience by a community of women Much like I think probably many law students with disabilities do, we were essentially overachievers. We would sit in the first row so they couldn't ignore us, and do things of that sort. My career kind of wandered from civil rights law in the not-for-profit sector to civil rights law in the government sector, and kind of back and around again. Ultimately ended up at the State Department, the U.S. Department of State, doing civil rights law, and got an opportunity to transition to international human rights law, and that's what I do now. I basically learned international human rights law while at the State Department through both the end of the Bush administration and the beginning of the Obama administration, which was quite another interesting transition, to be sure. Not getting too political. Especially since I had to be on the US delegation negotiating the Disability Rights Convention, representing a government that didn't believe in the Disability Rights Convention. Well, I did. But anyway, that's always an interesting thing, you know, that we all have to learn as lawyers. Sometimes we don't like our clients. Sorry. But there were a couple of lessons that I learned through those various experiences. The first one is, it really is important to have a mentor, or what I sometimes say from my feminist perspective, a womentor. Because, you know, when I was going to law school, there really weren't lawyers with disabilities and very many around. And there clearly weren't very many women lawyers in general who were highly accomplished. I shouldn't quite say it that way, who were recognized for their accomplishments. And there were very few that I didn't know of any women lawyers with disabilities to be the people that I relied on, and who could help me to guide my way. I did have a couple of women who were supportive, and a few good men as well, one of whom is here, my dear partner, Frank. But I really think that it is extremely important, and I think that's one of the things this kind of an organization can serve by bringing together somewhat more experienced lawyers with law students, and to really have someone of that sort. And I think that's a mutual benefit. My mother used to always say that each year she grew older, she tried to find a friend who was younger than her youngest friend, because the only way you are contemporary, as far as I can see, is to be associating with people who are not only your contemporaries, but who are the generations that will follow you, or who will help to lead you to an understanding what is new and what is exciting. So I think that's very important. But I will give examples of just as my sister here did, I will give examples of two experiences which were contrasting. But mine are more attitudinal, and my responses to them. I worked in one environment, in a not-for-profit, actually, which was a civil rights, civil liberties organization, and essentially found myself, although I had instincts when I first went through my interviews that this might not be the person I would want to work for, I did in fact take the job, which is why I agree with your point. Don't do that if you get bad vibes as much as you want and need a job. And really, she was basically a person who was of the view, I would say, that a person with a disability, especially a person with a visual disability, really can't do very much. I wasn't quite sure why she hired me, but anyway, but I didn't really stand up to that. You know, I sort of allowed myself to be abused, I guess I would say, and I escaped it by just quitting the job. Now, my second example of a similar situation is that I also worked for another person who was basically one of these people who would sort of try to embarrass you in public. not so much by tripping you up or whatever, but by just saying things that were totally inappropriate in a public setting. And finally, at a certain point, with a certain degree of arrogance, I said, it's not acceptable for you to talk to me like that. And it was astounding because, just like the bullies that many people experience, that was referenced previously and in the earlier panel, I think that people like that often respond better to you demonstrating your own self-esteem and asserting your own worth and not taking any expletive deleted from some employer. And I really think it's important to do that. It's not only important for creating a better work environment for yourself, but it's also really important for letting the world know that you are a strong person who has self-esteem. It's a very difficult thing to do because it feels risky. Some people would describe it as insubordinate. I think it's insubordinate to speak with one's fellow sister worker in that way. So those are my kind of two lessons. Find a mentor, build a strong relationship with that person and learn from one another. And the second one is really don't take any crap. The quickie other one is if you love disability law, that's fantastic. Do it. If you don't, but they keep trying to put you into the disability slot, say, I'm really more interested in patent law, or whatever that might be. And because you don't really need to do that job if that's not what you find passionate. It doesn't mean you don't support disability rights. It doesn't mean that you don't think that the issues are important and interesting. It's just your passion lies somewhere else.
Well, I'm going to pick up on some of those themes that were just discussed, but I guess let me start by saying that I view my disability as being actually a net positive and something that opened up opportunities for me that never would have been there had I not had a disability. Of course, I've got two artificial legs. I was in a car wreck when I was 10 years old, and so I lost my legs fairly early in life, and I've been walking around on artificial limbs ever since. And that's an orthopedic disability. That's something that doesn't impact, from a lawyer's perspective, it doesn't impact the ability to think or process information or hear or see. And so I must tell you that it's inordinately easier to deal with something like that than it is to deal with a whole host of other disabilities. In fact, I know some veterans who have come back from the wars, recent wars that we've had. And in the wards up in what used to be Walter Reed, where a lot of the wounded warriors recover, they refer to amputees like myself as having flesh wounds. They're just so insignificant that compared to some of the other injuries that veterans come back with, that's kind of how they think of them. That's how they refer to them. And in that light, I guess I've never really felt, maybe it's happened behind my back, but I've never really felt the kind of the crushing disappointment of discrimination based on disability. Quite the contrary. I've been blessed by having some opportunities that I never really would have had it not been for disability. In fact, I credit getting into Georgetown Law School, quite frankly, with my disability having a real positive influence on that decision by the admissions office. And they're looking for diversity just as much as they're looking for diversity in many other ways, geographic and racial and gender. They're looking for, to seed a law class that has disability diversity as well. And I'm quite sure, even though it was never told to me or said to me directly, I'm quite sure that that impacted the decision. I would say that, my experience with law school and Washington and lawyer and becoming a lawyer, I had always wanted to be a lawyer. And in growing up, high school and such, I would always be the person that would be speaking in class, I would always be the person that would be arguing on behalf of someone else. People would come to me and for advice sometimes, which is kind of odd as a 15-year-old or 16-year-old. And I kind of had that view that that's what I would kind of do. When you have a disability, my sense is that you're more mature than most people. You grow up pretty quickly. Maybe that's your experience, maybe not. But it strikes me that you're dealing with some pretty significant issues that others aren't dealing with, and I think people recognize that and kind of gravitate to you for that. I hope I'm not being self-congratulatory anyway. I'm just trying to be honest about how my experience with growing up in that way. But I would say that when I went to Georgetown, I really did enjoy Washington, kind of being in this city and all that it represented in terms of the power structure and the politics and the decision-making and the policy. But I really became invested in being a lawyer around legislative and regulatory issues when I began volunteering my time for an association to try to promote prosthetic and orthotic device access and access to artificial limbs and technologies that weren't available at the time. This is now back in the late 80s, 1980s. And I volunteered my time and actually worked with an association that I currently represent. I now turned them into a client, if you will, over the years. But was successful in getting something called the Claude Pepper Act for Amputees passed in 1989. And that was my last year of law school, and I got to tell you that was a thrill beyond words. I didn't do it single-handedly by any means, but I was really engaged in it. I was very involved in it. It had nothing to do with law school, but it was exactly what would lay the foundation for what I wound up doing with my law school education for the rest of my career. And that bill, the day that bill passed, and I helped change federal law to benefit people who needed prosthetic limbs, that was a big deal in my mind. And that was really something that I wanted to do more of. And so that's what I did. And I was lucky enough to find an employer in a small firm who represented the rehab doctors. And that employer, recognized, I guess, my disability as actually a strength. The fact that when you're representing rehabilitation interests before congressional committees and federal agencies, for you to be using technology, for you to have gone through an inpatient rehabilitation hospital experience, for you to have experienced disability firsthand, gives you a certain credibility, kind of an instant credibility, that many others just don't have. And so that's a net gain. That's a net positive. And so don't be afraid to embrace that, and I think and think of it that way. And I think all you need to do is look at yesterday's news story that ran throughout and became viral on the internet about a couple in Oregon who is suing their obstetrician because their son or daughter, I'm not sure, their child was born with Down syndrome, and they had requested a test to test for the chromosome, and the test came out negative, and the child was born. And the parents are now suing the doctor for $3 million because the child has, quote unquote, ruined their lives. And I got to tell you, that kind of story is just one illustration of how desperately the disability community needs good advocates, needs good lawyers, needs good spokespeople, needs good rank-and-file organizers and grassroots people to go up to Capitol Hill, to go to the federal agencies, to go into the state houses across the country, and to advocate on behalf of people with disabilities. And so it's a critical need, and it's not going away. However, I have great respect for those who break out of that mold, who actually go into other areas of law and take their disability with them. They don't wear it on their sleeve. And by the way, I do. There's not an audience that I get up in front of where I don't tell them that I use 2 artificial legs, because that's kind of what my shtick is all about now, right? So I don't have any problem wearing it on my sleeve, and I do it all the time. I really appreciate the people who don't. and the people who go into tax law, or the people who go into clerking for a judge, or the people who go into all different areas of the law. And disability is not the main focus of what they do. But that example that you set is more valuable than you know. And it is picked up, people get it, people understand it. And it's really important that we not just create kind of, that lawyers and law students with disabilities don't just look at the disability field as the major area that they should be going into. I don't want to dissuade anyone from doing that if you're interested in doing that, because we need good advocates. But it's really it's really important that not define who you are. And if you, I'm parroting what I just heard, but bottom line is if you have a desire and an interest, you're not bound by your disability in any way, and you should think of that service and that career path as being just as, if not more valuable to the overall issue of disability in America as going into disability rights. So I'll end with that.
Yeah. Brette?
I just wanted to add to that. When I was working at the private law firm, I interviewed at the Impact Career Fair, which is the disability Students with Disability Career Fair here in DC each year. And I will say, on top of what Stephanie and Peter said, if disability is your passion, absolutely pursue it. But if you want to have a more general career, or you want to get a job at a private law firm, you also need to communicate that you want to do everything, or you want to do what that firm has, because we saw some really great candidates who I wanted to bring in, and sometimes could bring them in for a callback, but ultimately the decision was made, their primary interest is healthcare law, and we don't do that, so we don't know if that's a good fit. And so also be aware of what job you're interviewing for, and you want that right fit. Don't try to jam a square peg into a round hole, because you won't be happy. But if you think that the job you're interviewing for is a job you want, make sure that you communicate that you're more than your disability and you want to do whatever type of law they do.
And I'll add to that briefly, which is I'm someone, I completely agree with you should go into whatever type of law you're passionate about and what makes you happy. We need good lawyers with disabilities out there in every sector. But if you are like me and you're somebody who was very frustrated with all the barriers she found in life and decided to go to law school because she wanted to be able to sue the bastards, or at least threaten to, or all the access barriers out there, disability litigation, I think we need more of us to be bringing these cases. I think it's interesting because there are very few lawyers with disabilities out there. We're growing, but and we are in some instances there in numbers, but people. The legal profession is not very welcoming to people with different types of disabilities, depending on where you are.
There are a few people who identify as having disabilities.
Yes. There's people who are disabled but don't want to say it, but they're part of the community too. So this is all part of our work. But I guess my point is, we're very. It's, one example, it's always been concerning to me that the ABA Commission on Disability isn't run by people with disabilities. We're one of the few minority groups where it seems to still be okay for a lot of the leaders to not be members of the community. And a lot of those folks are here and are fantastic attorneys and speakers and great. So not to slight anyone, but just to say that I hope that, we can cultivate more folks with disabilities who, to be very clear, who want to go into disability rights. No one should be pigeonholed, because that would be the worst thing ever, to be pigeonholed into anything. But just to say that there still is a dearth of us out there, and I think it feeds into the whole issue of we all need mentors. You know, one reason I left North Carolina is because I really wanted to work for an attorney with a disability, and I spent a summer up here working for Christine Griffin, who's been a big supporter of NALSWD when she was at the EEOC, because I was at the Equal Justice Works Career Fair in DC, and literally she like flagged me down and was like, I want a disabled kid working in my office this summer, and I totally wasn't there to interview for her, but ended up blowing off my other interviews and just being like, all right. Actually, I went to my other interviews. I just was not fully present for them because she was a very exciting person to work for. So I would just add that in. And I've got some questions, but also if panelists have questions for each other, maybe we can start there and then see what folks.
I just wanted to make one quick comment. And in the international human rights work that I do a lot of work on disability issues in the international arena, like at the UN and conferences and such. And it's really sort of quite interesting because since international disability law is a new emerging area of the law because of the adoption of the Convention on the Rights of Persons with Disabilities at the UN, it's interesting because a goodly number of the most prominent expert lawyers in this area are people who do not have a disability themselves. And it's just so interesting because the whole theme of the convention and its negotiations by the NGO community was nothing about us without us. So international law is really quite exciting, and I invite you all to explore that too. I know that the convention has not received a lot of attention in the US because when it was being negotiated, the US government had indicated it had no interest in ratifying it. Although now President Obama has signed it, but with our current Senate ratification, an interesting challenge. But anyway, that was.
I wanted to add to that. I was going to say earlier that even if you don't go into disability law, there are still many, many, many ways to be involved and contribute to the community. I am a devout generalist. I refuse to let anyone pigeonhole me. So I work on about 20 different issues. But, 25% of my docket right now is disability policy. So I've always been able to get that to work. But interestingly, when the law firm I was at was hired to help ratify the convention and do that government relations work, I said, I'd like to do that, and the partner who was hired to do it said, yes, I asked, and they said you were already maxed out on pro bono, and it's just like, you guys have got to be kidding me. You don't exclude the one person remaining at the firm who has a disability from the disability ratification work. Like that's just bad policy. Get over yourselves. But as Stephanie was saying earlier, sometimes you have to stand up for yourself on that.
We've got questions.
Well, I'm always impressed at the range of things that lawyers with disabilities do in DC. I'd love to hear a little bit more from each of you about the cases that you worked on, more specific projects and regulation and policy and international law, and when you were at the Supreme Court Department and Mayor Brown and disability rights advocacy as well.
Can you want to hear specifically about DC?
Cases and projects that you've worked on as a lawyer at different firms and nonprofits, things like that.
Can you repeat your question, please?
Sure.
Specific cases and projects that they've worked on.
Kind of like some of the work that you do as a lawyer.
Sure. So right now, one case I'm working a lot on at Disability Rights Advocates is we have sued several cities for not including people with disabilities in their emergency preparedness plans. So all cities, we hope, have plans that about how they're going to evacuate people in the event of types of emergencies. So this is everything from 9/11 to hurricanes and dealing with the issue of, honestly, it's the people with disabilities who are left behind and die, quite frankly. And a lot of cities aren't doing what they need to do to be sure that people can actually evacuate to shelters and that they can evacuate in accessible transportation and that they even got the notice in the first place in an accessible format that, hey, there's an emergency, you've got to evacuate, like you're in danger where you are in your home. Actually, Carla did a lot of work on this in our LA case, but I'm now working on a similar case in New York for people with disabilities. And also, we are working on actually just entered a structured negotiation agreement with UC Berkeley regarding access to print material for people with all types of print disabilities. So we're representing clients with visual disabilities, manual dexterity disabilities, learning disabilities, anyone who needs access to alt media. And we're looking at everything from accessing everything in the library at the same time and with the same level of accuracy as students without print disabilities to online course management. So I'm giving you two examples. One is the New York emergency preparedness case, which is in heavy litigation mode. And we're doing everything from reviewing documents to taking depositions and all of that. And then contrasting that with, we are litigators, but we also are, you can often get better results when you are able to settle a case and not go the route of litigation. So UC Berkeley really wanted, there are an instance where we sent them a letter and said, we've got complaints from all these students and they've got to do research and they can't access journals and, we need you to either let us know what you're doing to fix this or we're going to have to think about litigation. And, there are ones that came back to us and said, oh, wait, we don't want to litigate. We really want to work with you guys. So now we're working, we have a joint expert and we are working out a plan for how every single piece of print will be accessible. And this is part of a much larger project that I know Dan Goldstein and others have been working a lot on. And so we're talking to colleagues across the country to get it right and hopefully set a good model. So those are two experiences.
Now I know there are Stanford people in the room, but I just have to say, go Bears! Very, very proud of my alma mater right now. Sorry, guys. So projects I worked on at the law firm, I was in Supreme Court and appellate practice. So my first Supreme Court case was Caperton v. Massey, where we bought a judge for $3 million. Private practice. Don't always like your clients, as Stephanie was saying. Although she was not speaking of private practice when she gave that example. It's equally true to private practice. I also litigated the Archstone case in both Fourth Circuit and Supreme Court cert briefing, which was trying to say that it was not just the housing developer who was responsible for compliance with the ADA, but also the contractor. And so the contractor could not claim that indemnity claims were preempted. Sorry, that just got very legal very quickly. But trying to hold the contractor liable for reimbursing the developer for the ADA liability and settlement costs. And goodness, medical device preemption. We had probably 20 cases on that and just a whole range of cases in the courts of appeals. Now I work on all the disability regulations, also forensic science reform, capital counsel, providing adequate counsel to people in post-conviction proceedings, and really so many other things, regulatory reform, and just a mix of things that changes day to day.
perhaps I'm the only person during the day here who's going to talk about international law. I think I'll give a couple of examples from international legal work. Just last week, seems months ago, but it was actually just last week, I attended the United Nations Commission on the Status of Women. What that is, it's a yearly meeting of the UN, basically where governments meet and NGOs come as well. It's the follow-up to about the implementation of the Beijing Declaration, which was the Declaration on the Rights of Women that emerged from this conference in China in the 90s. And it's very, very powerful, and there was a really strong delegation of women with disabilities who attended that and advocated for the rights of women with disabilities, so there's a strong statement there. But what I have noticed in my various areas of work is that often women with disabilities are ignored in the women's work, if you will, of the UN. So for this session, the theme of the session was rural women, but in all of the some 33 preparatory papers that had been prepared, only 3 of the papers included any references to women with disabilities, and that totaled approximately 10 lines cumulatively. So I guess there are no rural women with disabilities, which of course we all know is not true, around the world, especially in developing countries. But so what I did is I did last year at CSW, where the theme was science, technology, and engineering and math, is that I organized a side event. Basically, there are these somewhat boring government sessions where representatives of governments come up and give their pre-printed speeches that some underling has written for them. And then there are these side events, which are far more dynamic and, sorry. I was at sometimes one of those underlings writing those speeches, might I add, years ago. But so what I did was I organized this side event on rural women with disabilities, did it in cooperation with a women with disabilities group from Australia. We had an expert from Australia. We had co-sponsorship by that government. My purpose was to say women with disabilities are, in fact, as much as you all may want to deny it, women too. And so in addition to doing that, out of each one of these commission events, there are these so-called final conclusions. Now, last year I managed to get some references to women with disabilities into that. What do you think there was in the draft of the final conclusions that emerged for this session? Someone take a guess? Did women with disabilities appear in that document? No. Thank you. No, we did not appear in that document. So what I did was I took the document, what I learned from my days at the State Department about how to do line edits in UN documents, and I put in some rather discreet, I didn't go totally over the top, line edits to include women with disabilities, such as if you're going to talk about the Women's Treaty in the beginning paragraphs, why not talk about Article 6 of the Disability Convention, which is about women with disabilities? So, I did some fairly simple, light-handed edits. Some people thought I should have been a little nastier, but I actually wanted to get them in. So then next year, the theme of CSW is violence against women. Now, do we think that there are perhaps experiences of violence against women with disabilities that might occur? That might be something that should be discussed. So it didn't appear that there was any of that being considered as in the session that was organized around the planning for the next year's session. So I advocated very graciously, right, Frank? Frank was there with me. I was fairly pushy and obnoxious. People didn't, oh, I don't have any business cards. I said, great, write down your email, because there needs to be next year a preparatory paper that has a substantial focus on violence against women with disabilities, demanding that the issue actually appear in the draft conclusions as they're prepared, not that I have to do line edits once again. So I may soon start circulating an online petition. So I hope all of you will join me in signing that to get the UN Women's entity to ensure that we get to prepare a preparatory paper on women with disabilities and violence. So that's, since I talked too long, I'll only give that one example.
And I'll just mention one example as well. I've been working for the last 4 years on the Affordable Care Act, which ultimately the health reform law that passed 2 years ago this month. And the main thing that I've been doing for the last year has been working on the essential health benefits package. This is the package of benefits that every American is going to need to be covered by in 2014. And making sure that rehabilitative and habilitative services and devices is actually included in the benefit package that states are mandated to ultimately oversee, but that people are mandated to purchase, whether that occurs in the context of a private health plan or some other form of coverage in the public sector or publicly supported programs. So that term, rehabilitative and habilitative services and devices, we worked hard to get that included in the actual bill language, and it is required as one of the benefit categories to be included in the essential health benefits package. But now, exactly what does that mean? Making sure that health plans actually cover, rehabilitative therapies and inpatient and outpatient PT/OT speech and other therapies, prosthetic limbs and orthopedic braces and wheelchairs and durable medical equipment and hearing aids and vision aids and all kinds of things, speech generating devices that oftentimes insurance companies do not currently pick up and do not currently cover, or have certain arbitrary limits and dollar limitations and exclusions, and trying to make sure that that benefit package is as robust and as comprehensive as possible to meet the needs of people with disabilities and chronic conditions.
Peter, can you help me replace my power chair back home? Can you hold me take on Blue Shield? I know we had another question. I'll take that.
Yeah, I just wanted to address that several of you had commented on tremendous variability in both the reactions to and the responsiveness to requests or needs for accommodations within the workplace. And I wondered if, in all honesty, some of this may be out of ignorance on the part of employers, certainly, and that's not limited to the practice of law, but employers more universally. And what, if any, access to resource information you were aware of that could have facilitated that dialogue, helping you understand more about what accommodations might be necessary for you to facilitate job performance in the workplace, and also how to get that information to employers for their consideration or review. I mean, I know there's the Job Accommodations Network. That can be pretty general in terms of the content of information, and also acknowledging the needs for individuals with perhaps more non-visible disabilities and how they interact with the workplace, learning disorders, psychiatric disorders, etc.
I'll take that in the first instance. Yes, extreme variability, as I started my remarks with. And I do think a lot of it has to do with ignorance, whether willful or not. I will always remember the conversation that I had with the partners at the firm where I summered after the incident, where they said, we absolutely want you coming back and we want to provide reasonable accommodations, and they probably used the word reasonable accommodations 20 times in a 20-minute conversation. Whether or not they knew what that meant was a separate issue, and that's what your question goes to. I am forgetting what the website is, but there's a website out there that gives various accommodations that have found to be reasonable for different types. It is Jan. Okay. So,
are you aware of anything else out there that could serve as a resource or a consultant to, any individuals going into the practice of law where they need to think about the implementation of accommodations?
I mean, I use Jan, and for my personal experience, I think, and this is a defeatist way of going about it, but for my personal experience, it was more important for me to find people who were willing to learn about it and get it than to fight the uphill battle with people who could use the word reasonable accommodations for 20 times but had no idea what that actually meant. But I did use Jan with them, and what I did functionally was when I sat down in the interview, I said, this is how my vision works. This is what happens. So it's muscular, 8 minutes in, the words start to move on the page, 10 minutes in, it goes double, and I will sit down and have that conversation with every single person I work with. And so functionally, this is what helps me get my job done. If you can send me documents electronically before a meeting so that I'm not covering one eye during the meeting, trying to catch up. And so I will have that conversation of how my disability works and functionally what I need to then work in that environment. And, it's funny to watch employers in an interview because they know that they're not allowed to, some of them know that they're not allowed to ask certain questions, but I will try to offer the information. And at one point, at the firm I went to, he said, look, we know you can get the job done because we've seen your record. We've talked to the people who work with you. They all love you. We have no concern about that. I said, yes, I know. And I appreciate that you recognize that. But I want to functionally talk about what this will look like so that we're all comfortable with what might be necessary to accommodate it. And the other thing I did that, again, might have been avoiding an issue on my part is I went from a litigation practice to an appellate practice because appellate practices have defined records. There's no document review. You've already got the record. It's a discrete amount of record that you can easily scan, and in some ways is already electronically scanned. And so in that way, I could focus on my strengths while minimizing the impact of my disability. But that was a conscious decision I made. And it was a decision that I discussed with my employer in the process. Other thoughts on that?
Yeah, the only other thought, and this is fairly focused on visual disability issues, but there's, in and amongst the EEOC regs, there are some really good examples, if you will, practice notes within the context of the regs. And one of the ones that I found extremely useful, and basically I pulled it out and sent it around to give people some comprehension of what a reader does. I mean, you are alluding to the issue of, what is a reader in terms of providing assistance, especially with voluminous documents where every word is not what you need. You need some focused thing within the documents. And that particular EEOC reg really has an excellent description of not only the issue of what kinds of accommodations, but what the legal requirement is, essentially to enable a person with a disability to perform the duties of a job and to advance within his or her career path. So it's not only doing a minimal function, but it's also essentially being able to perform to the best of one's ability. I don't know that there's some generalized resources out there that employers will read, and then when you walk in the door, they'll be fully informed. I think regrettably that each one of us has the obligation, in reality, to educate employers about what we particularly need, because reasonable accommodation is an individualized assessment. It varies from person to person. One person with a visual disability may need a different thing. I mean, you and I need different things and to different extents. So I think really, and the other thing I really feel strongly about with respect to accommodation, it's essentially important to try to get it in place when you arrive. I've been in situations where, I spent a month once I arrived on a job not really being able to do the job effectively because the accommodation wasn't there for me. And that has a certain advantage of disclosure at a fairly early stage in the process, when you're offered a position, not to wait until you get there, because if the accommodation isn't there when you arrive, you'll be behind the moment you walk in the door, and that's just not really where you want to be.
Can I say one last thing?
Yeah.
This is probably, I don't know, borderline inappropriate to say, but
Go for it. We love inappropriate.
But and maybe this won't apply when you're starting out. Maybe it will. But the more successful you get in your career, the more accommodating your employer becomes. I'm telling you, when you are more valuable to an organization, you'd be surprised how generous the word reasonable becomes, because they recognize that they have a valuable employee that they don't want to lose, and so success breeds a willingness to accommodate. And maybe that's not the best lesson from the ADA. I don't probably think that's really replicated in the ADA at all. The ADA really is about making sure that you hire qualified people with disabilities and accommodate them to meet their needs with reasonable modifications and accommodations. But I will say that practically and in reality, as you progress in your career and you demonstrate value, I'll just say it one last time, that your accommodations become a real small investment compared to the value you bring to an organization.
So no, we're running up on time. I don't know if folks have any last words. I will just say, Brette was one of the people I called when when the bar denied my accommodations at the last minute. So just know, and then another Claudia Center, another mentor group helped me do my appeal really quickly within the 48 hours they gave me to do it. And I ended up getting my accommodations.
Did mine too.
And Brette got hers too, and it worked out. But just know that it's a tough road, especially getting into the profession and just getting started. It can be really hard, and hopefully this community provides some sort of backbone that you can draw on, and just know that you don't have to reinvent the wheel. You don't have to start from scratch. You can at least reach out to folks that have been there, and that's been one of the big values for me in the group.
Very quickly, I just wanted to share, the ABA actually has a really good website that became operational last Labor Day. Bill Phelan actually shared it with me. It's the BIAD. It's Bar Information for Applicants with Disabilities. It's a 50-state survey of things that you need in order to successfully apply for accommodations on the bar exam. So for the 2Ls and 3Ls who are in the room, you might want to jot that down. It's the BIAD on the ABA's website. It's a terrific resource.
And for human support, look to each other. Do you guys have any last words?
I just want to echo what Rebecca just said. Hopefully you can consider everyone in this room a resource, and I encourage you to do so. And reach out early and reach out often. We're all here for you.
All right, thanks. Thanks to Beth and the executive board for having us. And
thank you all so much. We have chocolates for the speakers. We have a 2-hour lunch break now, so feel free to take your time and walk around. We do have lunch provided in the back. It's already all set up. Also, the Department of Justice has a table right outside. They would love to talk to students. They have information about their summer programs and all types of things. Yeah.
Well, you're communication, right? Forever.
It was good.
I'm heading back.
Yeah. Working with
Oh, you work there. I work there. Right. I got myself.
Okay, I'll take a step back. Right. What year are you?
Yeah, when you mentioned that,
I have a list of copies.
you've got one event, you're in. Hi, Brette. Hi. I haven't met you before. Hi, Miss Victoria.